Last episode asked the uncomfortable question, what happens if the person who understands the wallet is not there? Here is the uncomfortable answer. Bitcoin does not recognize grief. It does not know who the executor is. It does not know what the will says. It does not know which family member was trusted. The network keeps enforcing the same spending rules it enforced yesterday. A court can determine legal authority. It cannot recreate a missing private key. A seed phrase can recover a wallet. It cannot decide who should inherit. That is the whole episode. A will is not a wallet, and a seed phrase is not an estate plan. Bitcoin inheritance has two systems that must meet. The legal system decides who is authorized. The technical system decides who can actually move the Bitcoin. If the legal plan works but the recovery path fails, the heir may have a claim to property they cannot reach. If the recovery path works but the legal plan is unclear, someone may have technical access without clear authority. Neither outcome is acceptable. The plan needs both. Start with the legal layer. In the United States, digital asset access is not one simple national checklist. State law, estate documents, account agreements, custody type, and the facts of the estate can all matter. The Uniform Law Commission created the revised Uniform Fiduciary Access to Digital Assets Act as a framework for fiduciaries such as executors, trustees, conservators, and agents. Its materials explicitly include virtual currency among the digital property a fiduciary may need to manage. But a model law is not a personal estate plan, and an internet video cannot tell you which document or structure fits your state, family, taxes, or custody setup. That is work for a qualified estate planning attorney and tax professional. The beginner lesson is narrower. Someone should be able to answer who is supposed to receive the Bitcoin, who is authorized to act, and where is that intent documented. Do not confuse those questions with the technical question, who can sign? That is the second layer. Technical access. With a custodial account, a company controls the keys. The estate process may depend on that company's current procedures, required documents, and account terms. With self-custody, there is no company reset button. Recovery depends on the wallet's actual design. A simple single-key wallet may have one kind of recovery path. A wallet with a passphrase may require more than the recovery words. A multi-key wallet may require keys plus wallet configuration. Bitcoin Design's inheritance material makes this point clearly. For a multi-key wallet, backing up private keys is not enough. The wallet configuration, sometimes represented by a descriptor, explains how addresses are generated and what rules control spending. That configuration may not spend by itself, but it can be critical to recovery and sensitive to privacy. The practical lesson is not to copy someone else's advanced setup. It is to know what your own wallet requires. If only one person understands the wallet type, the recovery method, and the missing pieces, that person is the plan. And people are not durable infrastructure. The third layer is discoverability. An heir cannot recover an asset they do not know exists, but discoverability does not mean publishing a treasure map. It means preserving a minimal, non-secret inventory. What kinds of holdings exist? Which are custodial? Which are self-custodied? Which wallets are active, retired, test only, or watch only? What professional or trusted role should be contacted? What document explains the next step? Notice what is not on that list. Seed words, private keys, passphrases, pins. This episode is not telling you where to store secrets or who should receive them. It is saying that the non-secret map and the spending secret are different objects. The map helps the right person find the process. The secret makes spending possible. Combining them carelessly can turn helpful documentation into a theft guide. The fourth layer is records. Bitcoin can move perfectly while the estate's paperwork is a mess. The IRS treats digital assets as property for federal tax purposes. IRS Publication 551 says the basis of inherited property is generally tied to fair market value at the date of death, subject to rules and exceptions. That does not mean you should calculate an estate from a YouTube video. It means records matter. What was owned? Where was it held? What was the date and time value? Which transactions happened before and after the transfer? What documentation did the executor, beneficiary, attorney, or tax professional use? The wallet history may show transactions. It does not automatically preserve the legal and tax explanation around them. That context has to come from people and records. The fifth layer is the human handoff. This is the layer most technical plans underestimate. Imagine giving a grieving family member a hardware device, a sealed note, and 12 words they have never seen before. They do not know whether the device is safe to connect. They do not know whether the node is current. They do not know whether a passphrase exists. They do not know whether they are looking at the right wallet. They do not know whether moving funds immediately is necessary, risky, taxable, or contrary to the estate process. That is not a handoff. That is a panic test. Bitcoin Design's inheritance work says technology is not everything. Knowledge, documentation, practice, and social processes matter over the long term. That is exactly right. The human plan should explain roles without exposing secrets. Who calls the attorney? Who identifies the current wallet? Who verifies that instructions are current? Who understands the difference between a custodial account and a self-custody wallet? Who should not act alone? You may decide that one person should not hold every role. That is a legal, security, and family decision. But the roles should not exist only in your head, and death is not the only continuity event. Incapacity can create the same collision between legal authority and technical access. The owner may still be alive but unable to explain the wallet. The family may have a valid power of attorney but no idea which account or device matters. Or someone may know the recovery material but have no clear direction about whether they are allowed to use it. That is another reason the legal and technical plans should be designed together. The plan should answer more than, what happens when I die? It should also ask, what happens if I cannot communicate? What happens if a device fails at the same time? What happens if the person named in the old plan is no longer available? And what happens if the instructions conflict with the wallet that exists today? You do not test those questions by exposing a seed phrase. You can run a tabletop exercise with no secrets at all. Give the intended person a fictional emergency. Ask them to identify the current inventory. Ask them which professional they contact first. Ask them whether the wallet is custodial, single key, or multi-key. Ask them where the authoritative instructions begin. Ask them what they should not type, photograph, share, or improvise. Then stop before any secret is revealed or any funds move. The goal is not to prove that they can spend the Bitcoin today. The goal is to discover whether the process makes sense while you are still available to repair it. If the tabletop exercise produces 5 different guesses, the plan is not clear. If it depends on a person who has never agreed to the role, the plan is not real. If every answer begins with only I know, the plan has a single human failure point. Here are 5 common failure modes. 1. The will mentions Bitcoin, but no one can find the wallet or recovery process. 2. Someone finds recovery words but cannot tell which wallet they belong to or whether something else is required. 3. The technical access works, but the person holding it does not know whether they are authorized to act. 4. The plan was correct 3 years ago, but the wallet, device, provider, relationship, or law changed. 5. The setup is so clever that only its creator can explain it. That last failure is the most seductive. Complexity feels like security because it is hard to understand. But if the intended heir also cannot understand it, complexity is working against the goal. Advanced tools can help. Multi-key wallets can distribute signing power. Time-based spending conditions can create recovery paths. Professional custody or collaborative custody can change who assists. Trusts and estate documents can change legal administration. But every added component creates something else to document, maintain, test, and eventually explain. There is no magic product that removes the human system. So what can a beginner do without turning a video into personalized legal or security advice? Run a non-secret continuity audit. First, can a trusted person discover that the Bitcoin exists without finding the spending secret in the same ordinary note? Second, does your legal plan clearly identify the asset and the people or roles authorized to handle it? Have a qualified attorney answer that, not a content creator. Third, does the technical recovery method match the wallet you actually use today? Fourth, could the intended people identify the correct professionals, documents, and wallet type without improvising during an emergency? Fifth, is there a review trigger, a new wallet, a new passphrase, a move, a marriage, a divorce, a death, a new executor, a major law or provider change, or simply a calendar review? The point is not constant tinkering. The point is preventing a dead plan from looking alive. Here's the clean mental model. The legal plan answers who should receive the property and who may act. The technical plan answers what can authorize a valid Bitcoin transaction. The continuity map answers what exists, what is current, and where does the process begin. The records answer what happened, what was valued, and what must be documented. The human handoff answers, can the right people follow the plan under pressure? 5 layers: legal authority, technical access, discoverability, records, human handoff. Miss one, and the inheritance can fail even if the Bitcoin never moved. That is the strange thing about self-custody. The network can work exactly as designed while a family still loses access. Bitcoin gives you property without asking permission, but it does not give your heirs your memory. You have to preserve the right context, involve the right professionals, and build a recovery path that survives the person who designed it. Next episode, we go one level deeper into multisig, what it can solve, what it cannot solve, and how adding more keys can turn one failure point into several when the human plan is weak. This is Exit Velocity. Think in Bitcoin. Educational only, not financial, tax, legal, security, or privacy advice.